Hi guys, welcome to our channel. I started making a series of videos on Indian Penal Code 1860 recently and I've uploaded a few videos. So I hope that you saw those videos, and if not, then please check them out. I request you to watch all the videos from our channel and also press the bell icon next to subscribe button to get all the updates on our upcoming videos. Also subscribe to our channel. Today this video is on chapter 4 of IPC, which covers section 76 to 106. Section 76 to 106 of this code is on general exceptions, which tells us about certain persons who are exempted from penal provisions of this code due to some circumstances or capacity as provided in this chapter in IPC. I hope this video will be helpful to you. In this video, I am going to discuss provisions from section 76 to 81, and the remaining provisions from this chapter will be discussed in the upcoming videos. This video is part 1. Section 76. Act done by a person bound or by mistake of fact believing himself bound by law. Nothing is an offence which is done by a person who is or who by reason of mistake of fact and not by reason of mistake of law in good faith believes himself to be bound by law to do it. Illustrations. A soldier fires on a mob by the order of his superior officer in conformity with the commands of the law. A has committed no offence. B. An officer of a court of justice being ordered by that court to arrest Y, and after due inquiry believing Z to be Y, arrests Z. A has committed no offence. Explanation. The first part of this section does not use the word mistake at all. It simply says that a thing is not an offence if it is done by a person who is legally bound to do it. When law asks a person to do something which he does, it is not an offence. A person is bound by law to do something when the law puts him under an obligation. Doing a legal duty is not an offence. A person who is bound by law to do something does not commit an offence when he does it. There is no question of mistake of fact, mistake of law or good faith under this part of section. The second part of this section deals in fact with the defense of mistake of fact. Under this part, a thing is not an offence if it is done by a person who because of mistake of fact and not by mistake of law in good faith believes that he is bound by law to do it. When a person is in fact not bound by law to do something, but he does that by reason of mistake of fact and not mistake of law in good faith believing that he is bound by law to do it, it is not an offence. Mistake of fact and good faith must be proved to be present, while mistake of law must be proved to be absent under this part of the section. In other words, the well-known principles, ignorance of fact is excusable and ignorance of law is not excusable, have been incorporated under this part. There may be a difference between ignorance and mistake, but they have been treated as same here. The expression mistake of fact means that there is a misconception in the mind about the existence of a fact. If truth or otherwise of fact is not known correctly, it is a mistake of fact. Mistake of law, on the other hand, is a mistake as to the existence or otherwise of a law that includes a mistake as to what the law is. The expression good faith has the same meaning as given under section 52 of this code. The Supreme Court has correctly appreciated the distinction between the two parts of the section in State versus Shiv Mangal Singh, where the facts were that police patrol party opened fire under the orders of the Deputy Commissioner of Police after it was attacked on a dark night. One Assistant Commissioner of Police was injured in the attack. As a result of firing by the patrol party, 2 persons were killed. After a lapse of about 9 years, the police personnel were prosecuted for murder. The Supreme Court, in the appeal against their acquittal, held that the prosecution did not succeed in proving the case against them. There was no question of proving the defense of mistake of fact by the accused. It is clear that the order of firing given by the superior officer to his subordinates was given under commands of the law, and therefore the patrol party was bound to obey the orders under the first part of section 76 of the code. Since the first part of the section was applicable, there was no question of proving of mistake of fact and good faith by the accused at all. Consequently, they were not held liable for murder. Illustration A in this section also states that when a soldier, while obeying the orders of his superior officer in conformity with the commands of law, fires on a mob, he does not commit an offense. The key words in this illustration are in conformity with the commands of law. The subordinate officer is protected only when the orders of the superior officer are in conformity with the commands of law. If such is not the case, he is liable for obeying the order. The expression means that the orders are justified and valid in the eyes of law. All the legal requirements of a just order must have been fulfilled. Only then is a subordinate officer protected under this section. Naturally, if the orders are blatantly illegal, neither the superior officer who gives the order nor the subordinate officer who executes or follows the same is protected under this section. In Charan Das Narayan Singh vs. State, where information was received that some persons were gambling in the tent, a party consisting of A, a superior officer, B, a soldier, were sent to make an inquiry. The party arrived and surrounded the tent. Soon after, the sound of a gun was heard and the deceased who was inside the tent was found dead. At the trial, B admitted that he had fired the shot but pleaded that he had done so in obedience to the order of his superior. It was held that the order issued by Superior Officer A was wholly unjustified and unlawful, and so B was not bound to obey it. Section 76, 79 or exception 3 of section 300 of the code did not apply. Since B was a young man of 20 years of age, was recently recruited and was having an exaggerated notion of his duties and authorities wielded by his superior, he was sentenced to rigorous imprisonment of 3 years only, and clemency was recommended for him. It can be concluded from the above decision that the law does not expect a person to obey illegal orders of his superior. The situation may sometimes be very unhappy for him, because when he obeys an illegal order, he may be liable to punishment under law, while if he does not obey an order even though illegal, he may be liable under the departmental action for disobeying his superior officer. Another important conclusion which can be drawn from this decision is that even though the defense may fail, the circumstances of the case may justify mitigation of penalty. Section 77. Act of judge when acting judicially. Nothing is an offence which is done by a judge when acting judicially in the exercise of any power which is, or which in good faith he believes to be, given to him by law. This section can be divided into two parts. Number 1. Nothing is an offence which is done by a judge when acting judicially in the exercise of any power which is given to him by law. Number 2. Nothing is an offence which is done by a judge when acting judicially in the exercise of any power which in good faith he believes to be given to him by law. Under the first part, a judge does not commit an offence when he does something in his judicial capacity while exercising a power which the law has given to him. Under the second part, it is not an offence for a judge to do something in his judicial capacity while exercising such power which in good faith he believes the law has given to him. The first part of this section is applicable when a judge is acting in his judicial capacity, does something while exercising such a power which in fact has been given to him by law. The law empowers him to do something and he does that thing in his judicial capacity. In such circumstances, he cannot be held liable for an offence. There is no question of good faith under this part. On the other hand, under the second part, the judge does not exercise a power which has in fact been given to him by law. He does something in his judicial capacity under such powers which he believes in good faith to be given to him by law. The judge has to prove good faith under this part. It must be proved under this part that even though the judge in fact had no such power under law, he in good faith believed that he had such power under which he acted in his judicial capacity. Only then is he protected under this part of section. the proof of good faith may be a little difficult proposition. Section 78. Act done pursuant to the judgment or order of court. Nothing which is done in pursuance of or which is warranted by the judgment or order of a court of justice, if done whilst such judgment or order remains in force, is an offence, notwithstanding the court may have no jurisdiction to pass such judgment or order, provided the person doing the act is in good faith believes that the court had jurisdiction. The section is natural corollary to Section 77 of the Code. It protects those who execute a judgment or order of the Court of Justice. The section says that whilst a judgment or order of the Court of Justice remains in force, anything done in pursuance of the same or warranted by the same is not an offence, even if the court may not have jurisdiction to pass a judgment or order, provided the person who does the act believes in good faith that the court did have such jurisdiction. The responsibility to prove good faith is on the accused, and good faith has the same meaning as given under Section 52 of the Code. While this section gives protection to such person against criminal liability, the Judicial Officers Protection Act 1850 affords protection to them against civil liability. Section 1 of this Act states, inter alia, that no officer of any court or other person bound to execute the lawful warrants or orders of any such judge, magistrate, justice of the peace, collector, or other person acting judicially shall be liable to be sued in any civil court for the execution of any warrant or order which he would be bound to execute if within jurisdiction of the person issuing the same. Section 79. Act done by a person justified or by mistake of fact believing himself justified by the law. Nothing is an offence which is done by any person who is justified by law or who by reason of mistake of fact and not by reason of mistake of law in good faith believes himself to be justified by law in doing it. Illustration. A sees Z commit what appears to A to be a murder. A, in the exercise to the best of his judgment exerted in good faith of the power which the law gives to all persons of apprehending murderers in fact, seizes Z in order to bring Z before the proper authorities. A has committed no offence, though it may turn out that Z was acting in self-defense. This section can be divided in two parts. Number 1. Nothing is an offence which is done by any person who is justified by law in doing it. Number 2. Nothing is an offence which is done by any person who, by reason of a mistake of fact and not by reason of mistake of law, in good faith believes himself to be justified by law in doing it. As is apparent from the above division of the section into two parts, the whole section does not deal with the defense of mistake of fact, but only the second part does it. The first part of the section does not use the word mistake at all. Therefore, the statement that Section 79 of the Code along with Section 76 deals with the defense of mistake of fact is true only to the extent that each of the sections deals with the defense only under one part, while the other part of each of these sections are devoted to matters other than mistake of fact. The first part states that when a person is justified by law to do something, the doing of that thing is not an offence. A person is justified by law to do something when the law provides him a right to do that thing. According to this part of the section, therefore, doing what is justified is not an offence under law. Matters relating to mistake of fact, mistake of law, or good faith do not come up for consideration under this part at all. The second part of this section, like the second part of Section 76 of the Code, deals with the defense of mistake of fact. Under this part, a thing is not an offence if it is done by a person who, because of mistake of fact and not by mistake of law, in good faith believes that he is justified by law to do it. When a person is in fact not justified by the law to do something, but he still does that by reason of mistake of fact and not of mistake of law in good faith, believing that he is justified by the law to do it, it is not an offense. Under this part of the section, mistake of fact and good faith must be proved to be present, whereas mistake of law must be proved to be absent. As indicated under section 76 already, here also it may be mentioned that both the principles, ignorance of fact is excusable and ignorance of law is not excusable, have been incorporated under this part of section. In Dhaki Singh versus State, a suspected thief who had been arrested by police constables escaped from a running train. One of the constables pursued him with a view to effect his rearrest. When he was not in a position to apprehend him, he fired at him, but in the process, he hit the fireman of the railway engine who was killed. The defense of mistake of fact under sections 76 and 79 of the code was rejected. The code held that there was no right to shoot under section 46 of Code of Criminal Procedure 1898, corresponding to section 46 of Code of Criminal Procedure 1973. However, exception 3 to section 300 of the Indian Penal Code was held to be applicable, and the accused was held liable under section 304, part 2 of the Indian Penal Code. In Bonda Kui versus M, the appellant, aged about 50 years, and her niece were the sole occupants of the house at the time of incident, the male members being away in Khalihans. In the middle of the night, the appellant saw a form, apparently a human being, dancing naked with a broomstick tied on one side and a tom mat around her waist. Believing it an evil spirit or a thing which eats up human beings, the appellant with repeated blow with a hatchet fed in the thing on the ground. She told her niece to come and see the spirit. At the suggestion of the niece, the Monda was informed. The deceased was recognized later as the wife of a brother of appellant's husband and was about 55 years old. Reversing the judgment of conviction and sentence of 6 years imprisonment, the Patna High Court allowed the defense of mistake of fact under section 79 of the code and observed that the state of society to which the appellant belonged and the fact that she was a superstitious woman were important considerations to decide as to whether she had acted in good faith. In Hayat versus M, the accused in the early gloaming saw a stooping child in a place which was believed by him and other villagers to be haunted. Believing the child to be a spirit or demon, he attacked it and gave blows which resulted in its death before he realized his mistake. He was convicted under section 304A of the code, and his defense under section 79 of the code was rejected on the ground that he had not acted in good faith. In Raj Kapoor versus Lakshman, the Board of Censors has given a certificate to the petitioner under the Cinematograph Act 1952 permitting public exhibition of a film. On being charged under section 292 of the code, the petitioner contended that once the certificate permitting public exhibition was given by the competent authority under the Act of 1952, they could not be held liable even if the film be obscene, lascivious, and tending to deprave or corrupt public morals. The Supreme Court, agreeing with the contention, held that once the competent authority in good faith issued the necessary certificate, the petitioner, producer, and other agencies were protected under this section, read with section 5A of the Act of 1952, at least because of their bona fide belief that the certificate is justified. Section 80. Accident in doing lawful act. Nothing is an offence which is done by accident or misfortune and without any criminal intention or knowledge. In doing of a lawful act in lawful manner, by lawful means with proper care and caution. Illustration: A is at work with a hatchet. The head falls off and kills a man who is standing by. Here, if there was no want of proper caution on the part of A, his act is excusable and not an offense. Explanation. The defense of accident and misfortune is different from general concept of accident and misfortune as is commonly understood. To succeed under this section, the following essential elements of the defense must be proved. Number 1, something is done by accident or misfortune. Number 2, there is absence of criminal intention or knowledge. Number 3, the act done must be a lawful act. Number 4, it must be done in a lawful manner. Number 5, it must be done by lawful means. Number 6, it must be done with proper care and caution. If any of the above mentioned 6 elements is absent, the defense under this section will fail. The words accident and misfortune used in this section have not been defined under the code. There is normally an element of unforeseeability in these, and intention and knowledge are absent, while the consequence will generally be harmful or bad. All kinds of accident or misfortune do not provide protection under this section. The defense is available only when all the 6 requirements as indicated above are fulfilled. The accused and the deceased were wrestler friends. On the day of the incident, when they were having a wrestling bout in an akhada, the deceased was thrown on the ground. His head came to contact accidentally with the nearby staircase and he died. There was no foul means employed by the accused wrestler. It was held that all the essential requirements of the section were met, and consequently the accused was entitled to the benefit of this section. The accused was attacked by a person. To save himself, he fired on his assailant, who managed to escape, but in the progress 4 other persons were accidentally hit, one of whom died later. It was held that the accused was entitled to the protection of this section in addition to his right of private defense. The accused, along with few companions, went to shoot a pig. He took his position while the others proceeded to beat the pig towards him. A boar was driven in that direction and he shot at it. The shot missed and the animal, but it hit one of the beaters, resulting in his death. It was held that section applied, the accused was not liable under section 304A of the code. 2 brothers were sleeping with an iron rod kept nearby. In a state of semi-sleep, one of them felt that someone was strangling him. He caught hold of the iron rod and gave a blow which fell on his sleeping brother, who was killed in the process. The accused was so ashamed of his act that he even thought of taking his own life. It was held that he was protected under this section. The Nagpur High Court has held that shooting by an unlicensed gun does not deprive one of this defense if the essential elements of this defense are proved. The accused was beating a person with fists. The wife of the man being beaten intervened with her baby in arms with a view to rescue her husband. The accused gave a blow to her also, which accidentally fell on the baby, as a result of which it died 2 days later. The court rejected the defense primarily because the act of the accused of beating was not a lawful act, a basic condition required under this section. In Bhupendra Singh vs. State of Gujarat, the accused constable who had killed a head constable pleaded that the deceased got killed at the hands of the accused in performance of his duty. It was proved that the accused had fired from close range without knowing the identity of his target. The Supreme Court held that this fact showed that the act was done without any care and caution, and the accused was not entitled to the benefit of Section 80 of the Code. Section 81. Act likely to cause harm but done without criminal intent and to prevent other harm. Nothing is an offense merely by reason of its being done with the knowledge that it is likely to cause harm, if it be done without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harm to person or property. Explanation. It is question of fact in such case whether the harm to be prevented or avoided was of such nature and so imminent as to justify or excuse the risk of doing the act with the knowledge that it was likely to cause harm. Illustrations. A. A captain of a steam vessel suddenly and without any fault or negligence on his part finds himself in such a position that before he can stop his vessel, he must inevitably run down to boat B with 20 or 30 passengers on the board unless he changes the course of his vessel, and that by changing his course he must incur risk of running down a boat C with only 2 passengers on the board, which he may possibly clear. Here, if A alters his course without any intention to run down the boat C and in good faith for the purpose of avoiding the danger to the passengers in the boat B, he is not guilty of an offence, though he may run down the boat C by doing the act which he knew was likely to cause that effect, if it was found as a matter of fact that the danger which he intended to avoid was such as to excuse him in incurring the risk of running down the boat C. B. A. In a great fire pulls down houses in order to prevent the conflagration from spreading. He does this with an intention in good faith to saving human life or property. Here, if it be found that the harm to be prevented was of such nature and so imminent as to excuse A's act, it is not guilty of an offence. This section deals with the defense of necessity. When someone does something knowingly that the same is likely to cause harm to another, it is not an offence if it is proved that he had done that without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding the harm to person or property. The person claiming the defense must prove that he did not possess any criminal intention to cause harm and that his purpose in good faith was to prevent or avoid other harm to person or property. The use of the word other and not greater in this section shows that to succeed in this defense, it is not necessary for the accused to prove that he caused smaller harm to prevent or avoid greater harm. The defense will be still available to him if he proves that he caused harm to prevent or avoid other harm to person or property. The only thing needed to be proved by him is that he acted in good faith without any criminal intention to cause harm. It is natural that it would be very difficult for him to prove good faith if he causes greater harm to prevent or avoid smaller harm. The illustration A under this section needs to be seen in this perspective. In the famous case of Dudley versus Stephens, the accused were seamen. Their ship having capsized in a storm, they, along with a boy about 17 years of age, managed to float on a wooden plank. They continued to drift for many days without food and drinking water. When continued to drift for so many days without food and drinking water, when death by starvation of the three was almost imminent, they killed the boy and continued to eat his flesh for a few days. When they were rescued, on being prosecuted for murder, they pleaded that self-preservation was the necessity and they had no option except to kill the boy. Both accused were held guilty of murder and their defense of necessity in the form of self-preservation of life was rejected and they were sentenced to death. This sentence was, however, reduced by the Crown to 6 months' imprisonment. The explanation under this section states that the nature and imminence of the harm to be prevented or avoided is such as to justify or excuse the risk of doing the act knowing that harm was likely to result is a question of fact. There cannot be a general law governing this aspect, and the facts and circumstances of each case will decide this question. Thank you for watching. Please like, comment and share the video. Also subscribe to our channel. Keep coming back. Thank you.